Thank you all very much for participating in this conference on enforcing integrity. It actually, for some of us, has been part of a series of discussions of this sort in San Francisco, in New York, and then today. And we've been pleased to have a very extraordinary corporate leader associated with these efforts that helped think of the idea, to organize and sponsor with his excellent staff, to put on these conferences. Obviously, the emerging role of federal, state, and occasionally local law enforcement and other leaders that work on the area of corporate responsibility is very substantial for us as an association. I'm pleased to invite, for purposes of a welcome, this San Francisco corporate leader who also is the person who endowed and organized the Shorenstein Center on Press Public Policy at Harvard. And that center, as well as his personal efforts, of course, have regularly been associated with the inquiries into the intersection of press, politics, and public policy. A good friend, Mr. Walter Shorenstein. Walter.
Thank you, Bill, and I'm delighted to participate in this wonderful endeavor, and gratified that we're able to do this. As the owner and developer of commercial real estate nationwide, I have inherent faith in the strength and integrity of American business. As our success has been fueled by aggressive national markets funding uniquely entrepreneurial culture. But our capital markets are built on a foundation of trust, and that foundation has been badly shaken. In recent years, revelations of unprecedented corporate corruption has shaken investor confidence and bankrupt workers on the verge of retirement. After discussing this problem with my good friend Bill Locke here, we agreed that it was essential to mobilize all available resources to restore faith in American business. Since then, we have held events in San Francisco, New York, and New York. With the help of Liam Panetta, who's been an enormous factor in our being able to put these events together, to examine the breakdown of corporate integrity. Working with the Kennedy School at Harvard, along with the sponsors like Coca-Cola, Chevron, and General Motors, we have initiated a corporate social responsibility initiative to educate a new generation of business and policy leaders. While these efforts are part of a long-term solution, our nation's attorney generals are irreplaceable protectors of our nation's markets and its workers. Effective enforcement is the only way to rebuild confidence in our economy. I applaud the efforts made to date by so many of you, and I encourage all of you to do everything you can to ensure that our business climate remains aggressive and entrepreneurial, but also ethical and accountable. Thank you, and I'm pleased to participate.
Thank you. Thank you very much, Walter, for your assistance and personal friendship. The way we're going to do this is have each panelist make a brief comment. We obviously have distinguished economics columnists for the New York Times to begin that commentary. Tom Miller, Mark Schoenfeld from the SEC, Ralph Lambiase from his states and associations of securities enforcers, General Spitzer. And we hope to kind of have a succinct introduction from each of them on these topics of enforcing corporate integrity, and then want to open it up to some interaction and questions. So let's start with Mr. Jeffrey Maddock, economics columnist for the New York Times, editor of Challenge Magazine, an author of numerous both articles and other publications, as well as books, Taking America and the End of Affluence, adjunct professor of humanities at Cooper Union, and NASDAQ visiting professor of economics at New School University. Mr. Maddock.
Am I on? There you go. There we go. Very nice to be here. Thank you very much. They asked me to sit at the seat because they knew if they allowed me to get up to the podium, I'd be taking at least a half hour and maybe longer. I'm going to try to be pretty quick. And what I'm going to do is step back and try and set the stage for how we got to this place. The bottom line of my message is rules are good for markets. Markets don't work without rules, they don't work without regulations, and they do not work without enforcement. Somehow we got to a conviction in the US and in places of power that rules were guilty before proven innocent, that enforcement should be light. And I want to, as I say, I want to step back a little bit and see how we got here. How did this conventional wisdom develop in the late 1990s, and how did this scandalous behavior occur? The first thing to know is the market, in some sense, and I don't mean this facetiously, the market worked. The payoff to fraud, malfeasance, dishonesty was very high in the late 1990s. When prices are high, you get a lot of supply. And we had a lot of supply of fraud. That's not so much a joke. But how did we get there? Well, I think this started back probably in the 70s, but maybe the 1980s. In the good old days, you know, managers of corporations, even people on Wall Street. I remember my friend Leon Levy, who started Oppenheimer and Company and then Odyssey Partners. He was a very successful businessman. Always said the great fortunes were not made by managers of companies. They weren't even made on Wall Street until the 1970s and 1980s. They were made by people who started big business. In the 1970s, remember, the U.S. economy was severely challenged by the Japanese and European imports. Stock prices, many people forget, didn't go up for 12 or 14 years. It's remarkable to me how some young people do not believe me when I tell them that. We thought something was fatally, or at least seriously wrong with the American economy at that time. And a lot of people gravitated to the business manager. They said, and I think partly correctly, the business manager was not operating a business like an owner. How do we make these business managers owners? So the first step was, let's try and get them to act like owners. And many people thought this is the problem with the American economy. Indeed, it was the underlying philosophy of very successful CEOs like Jack Welch. But then we started taking this big steps farther. Managers might start acting like owners, but how do we make them act like owners? We give them stock. And we took another step further. We give them stock options. Now, owning a stock option is not like owning a stock. You don't have any downside risk. You can sell at the high. You can sell when it goes up. You don't have to stick with the company for the long run. Lots of problems there. How did this philosophy develop? Why were we so accepting of it? Well, I think a lot of it had to do with the general acceptance that markets are the best decision makers we have. Now, in some sense, that's true, but it's not purely true. And it's especially not true when you don't have rules and regulations and enforcement. Let me try and explain how far this economic theory, so-called agencies theory, went. There was a professor there, he's now emeritus at Harvard Business School, and I don't mean to pick on Harvard Business School because there were a lot of professors there who disagreed. And he made the claim that business managers should only worry about the stock price. Now, where did that idea come from? Because we all know stock history. We know stock prices go up and down madly, fluctuate, that volatility is crazy, that sometimes they think the world is rosy and sometimes they think prospects are terrible and nothing really fundamental has changed. He got the idea from something called efficient markets theory. You can't beat the market because the market incorporates all the available information very quickly in the stock price. Now, probably most of you have heard about that. And yet, He and others, I believe, made a still further jump. Why they made that jump is very easy. Not only did they say the market is efficient, they made the presumption that the stock price was right. The stock price almost always reflected the long-term future value of the firm. Now, that was an extraordinary leap of faith based on almost nothing. And indeed, when I've spoken to Michael Jensen, the leading exponent of this idea, he denies that. He says, no, I never really believed that. But that was the dominating philosophy of the time. So what was the job of managers? The job of managers was to get that stock price up, and therefore you compensate them. Well, we've discovered that the markets don't work quite like that. We've discovered the markets can be fooled. We discovered if you do present false information, the market and the stock price might believe it for a while. But what I find fascinating is how quickly, for a variety of reasons, we came to believe as a society this fundamental theory that the stock price knew something more than the rest of us knew something about the future that the rest of us couldn't figure out. And once we adopted that as a guide, once we adopted that as the single measure of performance and the single objective of a CEO, it became fairly easy to imagine how to manipulate that stock price. And not only were the CEOs part of this game, so were the Wall Street people, so were the institutional investors part of this growing conventionalism, and I think so were a lot of regulators in Washington. There was, I shouldn't say regulators, so was a lot of the Washington attitude oriented towards this. So we developed this attitude that no, regulation isn't it isn't as necessary as it once was. Why? Because the stock price itself was the ultimate regulator. Markets regulated. Markets would get rid of prejudice in labor markets. Markets would not allow deceptive practices. Markets would force managers to provide the most honest financial statements they could. We know much better than that. What's coming along to replace it? I'll just take one more minute. I think academics are thinking more broadly. There are ideas like balanced scorecards where you take a lot of consideration, a lot of criteria into consideration when you're managing a company. There are ideas about other stakeholders in the company, not just the shareholders who have a right to be treated or at least to be attended to, from the people who work there to the bondholders. So I think it's broadening, but I don't think it will be enough. And to repeat this one notion, I think clear-cut, well-enforced rules are necessary for markets to do their job. Ethics, as far back as Aristotle, were considered, at least by philosophers like him, a branch of pragmatics. They were devised to make society work better. And the same, I think, is true of the markets. So I applaud all your efforts to try and enforce, to develop new regulations and enforce these regulations. Well, I think it's been a very difficult environment in the late 1990s to do it. I think that environment is changing. I hope it remains changed. Thanks for letting me speak to you.
Thank you very much, Mr. Badger. Now, interesting. I want to ask our colleague, General Tom Miller from Iowa, who's chairs the new task force on corporate responsibility, and make his introduction.
My discussion will center around relationships, which obviously have become increasingly more important for attorney generals and for many others in the public sector generally, but in regulation in particular. 3 times sort of the light has gone off in terms of my head when I've heard quotes or discussions. One was yesterday when we had that wonderful session with Justice Kennedy, and where he talked about many topics very passionately, but in particular talked about federalism. And when he said that when our founding fathers developed our country and our Constitution and dealt with federalism, what they did in terms of government was split the atom. Second time was last December at Columbia Law School, when the renowned professor, corporations professor, John Coffey of the Columbia Law School, said, you know, if we believe that competition is good in the marketplace, maybe competition is good to some extent in regulation as well. And finally, at an ABA antitrust section meeting in the recent past, when we were talking about antitrust enforcement, the role of the states, and a couple of the speakers brought the topic into really good perspective for me. And they said this basically, that antitrust enforcement is a decentralized model. I said, well, look, the federal government had split between the Department of Justice Antitrust Division and the FTC. The states have a role granted by the Congress, and much of the litigation is done in private litigation by private parties. Indeed, most of the leading Supreme Court cases in antitrust are private party litigations, not government enforcement. So with this as a background, what I'd like to do is just talk fairly briefly about securities, about, again, a somewhat decentralized model. Obviously, you have a great authority in the SEC, who shares that authority, at least in part, with DOJ in terms of criminal prosecutions. You have a division of authority at the state level with our partners, the securities administrators, and we'll hear from Ralph next, and the AGs. Sometimes local prosecutors in the criminal area as well, and prosecutors in our office, and then the private party actions. So that's really, I think, the backdrop to see this all in. And the question really is not, is there only one player or a few players, or how should players be excluded, but how does it all fit together? And I think it can fit together in a very good way, with sharing of responsibility and sharing of resources and good judgment, and the obvious pursuit of the national interest, of the citizen's interest, the consumer, the taxpayer interest. When I look at things like creativity, one of the great things of the federalism system is that states are laboratories of democracy. Do I have to be a little louder? Okay, is this a little better? That states are laboratories of the democracy and do things a little differently, come up with some great ideas. And that's true in the regulatory area as well. And of course, the great example of that is what Eliot Spitzer has done in the securities area. First, in the conflict of analysis research, and secondly, in the mutual fund area. If it were not for his office and the law in New York, this whole environment, this whole discussion would be completely different. So, one state, few states can have great ideas and make a difference. Resources is another question. With budget cuts everywhere, including the federal government, and it looks like with the federal budget deficit, there'll be more cuts in the future. No one agency, federal or state agency, has the resources to do all this. Also, there's some checks and balances here. And that's one of the great geniuses of our Constitution and our founders, as Justice Kennedy mentioned, splitting the atom. That we love checks and balances, and that's an important part of federalism. And we see it here, that if one part of that mixture that I just described goes off to a fairly extreme end, somebody else in the composition comes in and plays a greater role. And I would argue that happened during the Reagan administration in antitrust and consumer, where they took, at least in my view, a very limited role of regulation, but the states then came into the vacuum. And that's what checks and balances are all about. Occasionally in America, those of us in the political process, I think, understand this, that the special interest can co-opt an agency or part of a government and have undue influence. But if that happens, then somebody else in the composition can do the appropriate enforcement in the public interest. If it happens at the federal level, the states can do it. If it happens at the state level, the federal government is still there. That's, as I say, part of the checks and balances, the genius of the federalist system. Also, there's the local-national divide that, to some extent, some of the enforcement is is peculiarly local or can be handled better at the local level, and the states then have the nexus to do that. You know, I think as I've enjoyed this wonderful job of Attorney General, one of the great things that I've been able to see is have at least a little appreciation of what Justice Kennedy said about federalism and about our Constitution splitting the atom. And the way I see it in a lot of ways is this decentralization of authority in consumer protection and antitrust and securities, and the challenges and the wonderful opportunities for all us players to work together, play the role that we're given with the resources that we're given, and serve the public interest in the best possible way.
Thank you very much, Tom. Next commentator is Mark Schoenfeld, who's the Associate Director of the Northeast Regional Office of the United States Security and Exchange Commission. He's been with them for several years, and thank you very much for joining us.
Thank you, and good morning. I don't know whether it's symbolic or ironic that Eliot and I are on opposite sides of the podium, because actually the thing that I wanted to talk about is the theme of cooperation and the extent to which our agency as a whole, and I think our New York office in particular, have achieved what I consider to be remarkable success when we have worked together with states, and obviously most recently and in the most high-profile sense with Eliot's office. I should start out, of course, with my traditional disclaimer, which is the views I'm about to express are my own and not those of the Commission, the Commissioners, or any of its other staff. But I do want to emphasize the fact that we have had remarkable success working together jointly on the recent investigations, particularly in mutual funds, and before that, in the analyst conflict of interest investigations and the global settlement that resulted. And as you can see in today's papers, we achieved another benchmark settlement with the Bank of America and Fleet for over $500 million in disgorgement, restitution, and penalties, along with other remedial reforms that set a new standard for these settlements. And I know from personal experience just how close that working relationship has been with the New York Attorney General's office, because I have been sort of playing the role of coordinator for all of the Commission's investigations in the mutual fund around the country, and in coordinating those investigations with various other law enforcement and regulatory agencies at both the state and the federal level. And I think that those on the other side of this cooperative relationship will agree that it is not an easy relationship all the time, but it starts with a commitment that both agencies are going to work together to a common result, that is to an enforcement action that will be brought jointly. And from that, once you start with that premise, the rest really becomes mechanical. It involves a lot of work. I am on the phone many times a day with my counterpart at the New York Attorney General's office and with my counterparts at other investigative offices. And it requires a commitment to cooperation, but I think we have that commitment, and the results speak for themselves. The investigations have been particularly challenging when the investigations have involved parallel criminal investigations. As you probably know, the SEC is purely a civil enforcement agency. Attorney General's offices and securities administrators at the state level obviously have the option to go both civil or criminal, depending on how they view the merits of the case. And that brings to them and to our joint effort, obviously, a substantial amount of leverage and strength in our investigative and prosecutorial efforts. But it does raise a great deal of cooperative complexities, and they require sort of a daily effort to work out how we're going to conduct those investigations jointly. But all of those are things that can be overcome, assuming you make the commitment to the common result. We've heard already about the issue of sort of regulatory competition versus regulatory cooperation. And I sort of approach this as an enforcement-minded lawyer, being head of enforcement for the New York office. And I realize that there is sort of a countervailing view or an argument that at the federal level, there is the value to sort of nationwide, industry-wide regulatory powers. And certainly we've seen in the mutual fund industry that one of the SEC's response in the last several months has been the promulgation of new regulations which are in the process of embodying much of what has been achieved on the enforcement level in individual cases. But as I say, I approach this myself as an enforcement-minded lawyer, and I actually find value in, as an enforcement lawyer, achieving innovative solutions to some of these problems. And our work with the states has, I think, helped achieve those results to bring to these problems unique solutions that actually bring meaningful relief. The other complexity, though, that arises here is that it's not just the SEC and the New York Attorney General. There are obviously a lot of other regulatory and law enforcement offices that are interested in these topics. And we see this at the state level, at the federal level, and even at the self-regulatory organization level. And so the complexities that arise are actually multiplied exponentially. And so what is required in coordinating these things is not just a state-federal coordination between the SEC and a particular Attorney General's office, but a coordination really among the multiple states, SROs, and federal prosecutorial offices that all want to bring their resources to bear to these kinds of cases. And so it is really a multi-level coordination that's required, and it really presents unique challenges. I think with respect to the Analyst Global Settlement in particular, there was a remarkable level of coordination and organization that was brought to bear, not just among at the federal level, but among the states, the attorneys general, the self-regulatory organizations, and the securities administrators to come up with a global settlement that really achieved remarkable results. So I think the main message is that with a commitment to cooperation and a sufficient day-to-day dedication to that outcome, we can achieve results together.
Thank you very much, Mr. Schoenfeld. Our next brief commentator is Ralph Lambiase, the director of the Connecticut Securities and Business Investments Division of their Department of Banking. We've worked together because he's currently president of the National American Securities Administrators Associations. Thank you, Ralph.
Thank you. Thank you. I appreciate the opportunity to be here before this distinguished body. And before I give you some particular comments, I'd actually like to express our deep gratitude to your association, the individual members, for the support that you've given us at the state level in aiding us to enforce securities laws and to help protect the citizens of our state. So with that, I'd like to, again, thank you for that and give you some comments. As we're responsible generally for the enforcement of state securities laws as administrators. We license broker-dealers, we license investment professionals, we register certain types of offerings, and we conduct examinations of broker-dealers and investment advisors. Like me, 8 of our colleagues, or my colleagues, are under the Department of Banking or financial institutions, 5 under the direct offices of the Attorney Generals, and also 10 under Secretary of States. The balance of my colleagues are actually in report to various commissions or boards. So we are a very diverse group of securities regulators. Each day, securities regulators, including many in this room and indeed at this table, work to restore investor confidence and trust in the markets. And how do we do that? We often do that, and I'll use some statistics to back up our point here. In the year between 2001 and 2002, the state securities regulators received something like 12,500 complaints. They filed over 2,500 administrative actions, of which 800 alleged fraudulent conduct. Further, states supported, either at the state level or in fact at the federal level, criminal prosecutions in 360 instances. Number of defendants convicted during that period of time exceeded over 300, with over 1,600 years of incarceration being meted out. I think that's the message that the public wants to see. You want to instill confidence back into the marketplace, then I suggest that the public is looking to the actions that are brought, the enforcement actions, to restore that integrity. I'd like to say that we work on many levels in terms of many endeavors. We work together on a multi-state basis, as may have been witnessed during the penny stock and microcap frauds of the late 80s. We've worked in large groups as on the analyst cases of late, but more often you'll see state regulators working in groups of 2 or 3, where we work that many more times. We share, we do depositions, we issue subpoenas on behalf of each other, we open our files, and we work collectively for the benefit of our citizens. And I think that protecting the investors is the primary role of the state officials, be it at the state or law enforcement at state level or at the federal level. That is the primary role that we serve. Government serves that role. And I think we have to stand for the premise that no one should really be able to tell the state elected official how to best protect its citizens. I think that comes from you and the mandate of the people that have put you in office, and I think that is something that we should hold in high regard. How in the future can we work together to accomplish certain of our goals, and how could we work to better our partnership? I would like to say that many times we need assistance from the Attorney General relative to whether it be subpoena enforcement, legislative support, complaint referrals, defending administrative decisions, civil penalties, restitution, disgorgement, rescission, and the big one, the criminal prosecutions. What we can do to help you, I think that what we can do is we can provide you the technical expertise regarding the industry and its operations. We can and we do put together a very exhaustive investigative file which will aid you in the prosecution of your case. With a state prosecution comes a strong message to the public, and that the defendants of white-collar crime, that it is taken very seriously. It sends to the defendants the clear message and convincing message that we are working together to protect the financial futures of our citizens. And that I would like to conclude my comments, but I would also like to expend our appreciation personally to Bill Lockyer and also to Bill Sorrell, your president-elect, for allowing us the opportunity to appear before your association. I'd be remiss if I didn't mention that Frank Woodman, the president-elect for NASA, actually works for the State Attorney General Peter Harvey out of New Jersey, and he'll be following me as president. And I'd also like to express publicly our appreciation to our own Attorney General, Dick Blumenthal, for everything he's done to support the residents of the state of Connecticut. But with that, thank you very much for this opportunity.
Thank you very much, Ralph, and we appreciate the chance to work together with AGs and all of your differently configured offices throughout the country, and you have a complicated job leading, obviously, that very diverse group. Thank you for your assistance.
Thank you.
Well, Eliot Spitzer, of course, is, I think, acknowledged by us all as the extraordinary pioneer in this enforcement area, and we're pleased that you're joining us today, Eliot. Please.
Thank you, Bill, for those kind comments. First, let me thank Walter Shorenstein and the Shorenstein companies. They've really done a wonderful job making it clear that there are voices in corporate America, very, very substantial voices, who support real efforts to restore integrity, and that the effort to hold individuals and entities accountable is something that is consonant with a very confirmed view to maintaining the vitality of our capital markets. So, Walter, thank you for supporting this effort. It's critically important. Let me also, right at the top, pick up on what Mark said before about the relationship not only between my office and the SEC, but I think all of our offices and the SEC. It is one that is by and large harmonious. And we all know when there's good harmony and bad harmony, but there are 99% of the time there is agreement among us on how to proceed with cases, where to end up substantively, and it has been, if the press occasionally loves to play up those points of disagreement, occasionally there have been those moments, nonetheless 99% of the time we're on the same page, reading from the same sheet of music, and it's been a wonderful relationship, for better or for worse. Steve Cutler's secretary, Steve being chief of enforcement to the SEC, knows my voice and knows what mood I'm in when I call and ask for Steve. And it's so we speak 4 or 5 times a day on most occasions about all the pending matters. Let me pick up for a moment on what Jeff articulated at the top, which is that rules are good for the economy. I would add 2 other rationales for government intervention, and the reason I begin with this is that I think it has become so much a part of our political discourse over the last couple years that we believe in the free market, we believe in a laissez-faire economy, and somehow there is a logical leap, an improper logical leap that has been taken that presumes that government intervention is somehow contrary to a laissez-faire economy and to the free functioning of the capital markets. I don't want to go off on this for any longer period of time than to say there are, at least in my mind, 3 distinct arguments for government intervention that are not only consonant with but necessary to the free functioning of the economy. One is the enforcement of rules, as Jeff said. If those rules are not enforced, you will not have either the integrity or the transparency in capital markets that are at their very essence essential parts of a vital capital structure. Argument 2 is that of externalities. Anybody who has studied economics knows that there are externalities, there are consequences to economic behavior which sometimes are not captured by the interchange between a purchaser and a seller, and where there are positive or negative externalities, sometimes government has to step in to say there's too much of that or too little of it, and we endeavor to increase or reduce the supply of a product based upon those externalities. And the third argument is one of common values, and that is the argument for child minimum wage laws or child labor laws. There are an entire raft of legislative enactments that reflect common values that we all share that are necessary areas where the government has to intervene in the marketplace, and that is in support of a free economy and laissez-faire economics, not contrary to it. Let me make a couple quick points about that have sort of struck me over the last couple years of litigation, negotiation in terms of the capital markets. Point 1 is that we had what I would call the perfect storm in corporate governance breakdown over the last couple years. We had, if you think of corporate governance as being that chain of decision makers from the CEO to the board, auditors, lawyers, investment bankers, institutional shareholders, every one of those constituent decision makers has a necessary role to play. If any one of them fails at any given moment, theoretically the others fill in the void. All of them failed simultaneously, I would argue, in the late 90s, and as a consequence we created what we have termed the imperial CEO. The effort over the last couple years through the global settlement with investment bankers, through an effort to re-articulate through Sarbanes-Oxley board and auditor responsibilities, through an effort through various settlements to beef up the responsibility of lawyers, et cetera, has been to redefine the responsibilities of each one of these links in the chain. So if we had a perfect storm, we're trying to recreate the proprieties of corporate governance, something that was frankly absent for too many years. I would give you one piece of data and then one footnote issue to that. The piece of data that I think proves that CEOs were simply empowered too much is a reference to their compensation. In 1980, an analysis was done of the ratio of the average CEO compensation to the average worker's compensation. The ratio in the United States was 41-1. The ratio in Europe was 18-1. That does not reflect a value judgment to good or bad. We have more vital capital markets, I think a more dynamic economy, so 18-1 may or may not be better than 41-1. Nonetheless, between 1980 and 2002, the ratio of 41-1 did not converge to the European average of 18-1. Rather, it exploded to 531-1, which is an absolutely astronomical figure. These numbers are not generated by some student somewhere or some academic who may have a political bias. These numbers were generated by the Conference Board, which is, I think, the bluest chip of blue chip spokesmen for corporate America. Pete Peterson, whom you may remember was the Secretary of Commerce under President Nixon, when he saw these numbers, wrote a little monograph saying, this reflects a breakdown of corporate governance, something has to be done. So this effort over the last couple of years has been to resuscitate corporate governance. Has it worked? Have CEOs gotten the message? Do they now share responsibilities? Well, until recently, until last week, in fact, I really thought we were on the right path, but there was an ad that was in the Washington Post, full-page ad, that was taken out by 43 or signed by 43 former CEOs in opposition to an SEC proposed rule on proxy voting. And some of the language in the ad, frankly, got me very concerned, and I will quote from it. The language reads that the proposed rule, quote, could enable large institutional investors with narrow short-term interests to infiltrate corporate boards. Now think about this. Institutional shareholders own the companies. The CEOs here are saying we aren't responsible to them. They're going to infiltrate our board. If there's been a problem, if there's a lingering problem out there in the capital markets, it's that institutional shareholders are not doing enough to flex their muscles, to manifest the responsibility that comes from equity ownership. Here we have CEOs viewing the institutional shareholders whose equity is at stake as guerrilla fighters trying to infiltrate the boardroom. This ad deeply worries me because it does not reflect to me that these CEOs at least understand what Jeff was referring to, which is that dynamic between management and equity. It seems to me that these CEOs have arrogated to themselves the rights of equity ownership and are viewing those who actually have equity ownership in a disparaging way that is inimical to what we were, at least what we were taught in law school, in terms of what that sharing of responsibilities and obligations should be. Let me move quickly to the mutual fund issue itself. There have been three distinct chapters, in my view, in the mutual fund investigations over the past 6 months. And as Mark referred to yesterday's settlement, we're now at about $1.65 billion back to shareholders, and the number will increase significantly over time with other settlements. The first chapter really related simply to the issue of timing and late trading. Straightforward improprieties in the markets, merely shining the spotlight on that, which has clearly resulted from the raft of investigations and settlements, I think has probably quieted that concern down. The second chapter was one that related to fees, and I know there was some back and forth about the propriety of dragging fees into the debate, but the fact of the matter is that in this fiduciary relationship that exists between the small investors and the large financial intermediaries, fees are a critical issue that we collectively as AGs, securities regulators, have to think about. If fees are not being set competitively, then investors are going to lose a vast sum of money, which is why we have, in yesterday's deal, there's a $160 million give back over a 5-year period, and we have had that in some of the other settlements as well over the last couple months. I would quote to you, no lesser an authority than Warren Buffett, and if you haven't read his shareholder letter, you can get it at berkshirehathaway.com. It's his annual statement to shareholders, and it's really, I think, really, folks in the investment world read it and give it enormous respect for all the obvious reasons. And what he says, he dedicates a page in there to the mutual fund debacle, and he really speaks in very, very derogatory terms of the mutual fund boards, and I'll get to that in a moment. But what he says is that mutual fund directors should be required to simply affirm in each annual report, and I'll quote, one, we've looked at other management companies and believe the one we have retained for the upcoming year is among the better operations in the field, and two, we have negotiated a fee with our managers comparable to what other clients with equivalent funds would negotiate. It is that notion of inserting competition, competitive bidding, and board responsibility that we have been aspiring to in the various settlements, and as I said, Chapter 2 in the mutual fund discourse with the companies really did relate to the entire issue of fees, and I hope we're making progress there because that is where the money is. Tens of billions of dollars a year that really are at stake in the proper negotiation of the fees, not only in the mutual fund context, but other contexts as well. The third chapter, and I think we saw the opening bell yesterday, is board participation, board behavior itself, and the reason that we sought the rather rapid shift over in board membership at B of A's fund boards is because when we looked at the records, we saw a record that did not suggest adequate participation in decision-making by the mutual fund board members, and they have a fiduciary duty. They've got to live up to it. And again, read Warren Buffett's letter on that, and you will see his rather derogatory articulation of how mutual fund boards have been fulfilling their responsibilities. Let me speak two last issues very quickly. One is preemption. And Congressman Oxley, I think, would be disappointed if I didn't raise it. He's become a good friend over the last year or so as we have jousted over the issue of the appropriate state role in the securities regulatory world. And I hope there is an emerging consensus that not only can competition among our various agencies be a healthy thing for investors and for capital markets, but that when that competition is tempered by the adequacy of cooperation among the various regulatory entities, it can be a net gain for everybody. And Congressman, I think you have seen that working quite well, as you heard from Mark and from all of us over the last couple years. And if there are momentary disagreements, really they pale by comparison to the importance of having the various layers of federal, state government involved in assuring that there is some core integrity in the capital markets. Finally, let me just end with one observation, and I think it's a challenge for all of us, because one of the issues or one of the conclusions I've reached watching the breakdown in the securities markets over the last couple of years is that certain of the institutions that we had relied upon have not served us well. Some of them are public, some of them are private. The public institutions are the SROs. The SROs, unfortunately, in my view, did not fulfill their mandate. They did not fulfill the regulatory obligation that they have had, whether it's the NYSE or the NASD or any of the others out there. They have not been aggressive voices on behalf of integrity in the capital markets, and somehow we need to figure out how we can revive them and lend some steel to their backbones, because clearly it has been lacking. The other voice that has disappointed me has been that of the industry associations. And here I would group the SIA, the ICI, and the AICPA that have, as industry voices, became too frequently, perhaps inevitably and uniformly, voices for the status quo. And as a result, by always articulating what the status quo needed to maintain itself, they opposed too often reasoned and healthy reform that could have avoided what became this perfect storm of corporate breakdown. If the SIA and the ICI and the AICPA were more forward-thinking and were willing to confront some genuine issues and go back to their membership and say, we've got a problem here, how do we confront it, then I think some of the issues that exploded in rather enormous form to the detriment of confidence in the capital markets could have been avoided. So I think the challenge that we face in government is how to revive the SROs. The challenge that the private sector faces is how to revive the industry voices that should be important parts of any reform effort. Thanks.
Thank you very much, Eliot. Eliot ended on the point I want to start with for anyone present to comment quickly with our beginning of our remaining time. If we were going to look back 10 or 20 years from now and hope to avoid the criticism that, gee, there was a real focus on this at the time, but what went wrong? What didn't we deal with to see in changing the economic culture or corporate philosophy or enforcement tools? What didn't we do that we want to make sure helps to minimize future problems of the sort that we've had? Anyone wish to open on that point? Only Eliot that wants to do institutional associations and SROs.
Well, let me come at it from a different angle, actually. I mean, the metaphor that I think captures all this, and because if you look back at the securities markets, we have scandals every 10 years. Or 50, or more frequently. And the reason is we don't remember the lessons we've learned. It's somewhat akin, and I've said this for 2 years, somewhat akin to watching somebody else get a speeding ticket. If you're like most of us, you watch somebody else, your first thought is, I'm glad they got caught, not me. And then you slow down. But you slow down for 10 or 12 miles, and then your foot hits the accelerator again. So I think one of the lessons that we as regulators need to learn is that we need to be persistent and diligent and not sort of step back after we've had these moments, a sequence of significant prosecutions. We've got to just be there on a regular basis.
Please.
John Kenneth Galbraith said in one of his books that you'll have a stock market crash as soon as there are enough people investing in the market who can't remember the last one. I think that's in some way reiterating what you just said, Eliot. I think if we look back, there was so much trust in the self-regulating capacities of the market, in pension fund behavior, in the so-called Chinese wall between investment banking and commercial banking, in the honesty of lawyers and auditors. The level of trust was enormously high because of this attitude in the public discourse about the self-regulating capacities of the market. So I think there was a broad scale reneging on responsibility for overseeing this that had something of a long pedigree that I talked about a while ago. The main ingredient we need across the nation, I think, is some level of skepticism and a loss of ideology and sort of a reassertion of pragmatics and just plain ordinary common sense.
I want to make, yes, Ralph?
Thank you. The way you pose the question seemed to be, what is it that we could have done? And I'm not sure that that's really what it is. I think that it boils down to the corporate side. Is the conduct that people engaged in, and is the consequences of that conduct adequate enough or to deter future conduct similar, or is it basically a cost of doing business? And I think that's the fundamental question.
Yeah, my point is, what should we be doing or thinking about doing now to avert future problems, not necessarily just a retrospective on the past problems or enforcement efforts. Tom?
Yeah, I just underscore what the others have said, and to give a very basic and fundamental example, but a good one, I think, and that is that in terms of constant diligence in the odometer rollback area, a much less complicated area. You know, 15, 20 years ago, we'd bring cases and it had stopped for a while and then it'd start up again. And what we decided to do is we needed an ongoing effort to watch that and watch it carefully. And you know, that's what this whole team has to do at one level. The other thing is to you know, look at the fundamentals when they're happening. Try and be aware of the things that were described in terms of the view of the market and the magic of the market. And also to look at excesses. I mean, there were excesses in the business community of one type or another in the late 1990s. And when they happen, some bad things are going to happen as a result of excesses. So I think to you know, day to day, keep our eye on things, but also look at the fundamentals and look at the excesses.
Eliot?
Let me also make another sort of more theoretical point that I think is especially important for Congressman Oxley and legislators, regulators here in Washington, which is that much of what we have seen, I think, is a convergence or a consequence of the convergence of two policy choices that were made in Washington. I'm not disagreeing with either of them, but I just think they were one of these unintended consequences you don't, of necessity, predict. The first was a desire to see increasing concentration in the financial services community. We repealed Glass-Steagall both at a regulatory and a statutory level based upon a concern that our financial sector could not compete with the overseas institutions, and so we wanted what I call the Citigroup model to exist. What that did was weave together many potentially conflicting strands of business that had never existed under one roof. Simultaneously, the second policy choice, and unquestionably an affirmative one, was to invite into the market the 100 million American investors who had not been equity stakeholders 20 or 30 years ago. The number of equity stakeholders has increased remarkably. What you then had was the interface between larger and larger financial sector companies and smaller investors. That interface became a very uncomfortable one. And often what happened was that large institutions began to see small investors not as individual investors, but rather as fee generators, and the fiduciary relationship that should exist between the financial institution and the small investor broke down. One of the regulatory or legislative issues we need to think about is how does a Citigroup or a Morgan Chase Bank One, you know, these names keep growing, how do they ensure that as they manage themselves, these various tensions are handled in a way that does not damage the small investor whom we have invited into the marketplace?
Eliot, don't answer this question, but since Procter & Gamble signed the letter 3 different times, does that mean they have especially strong feelings about this issue? Mark, do you want to perhaps suggest ways that you would recommend to AGs that are beginning to devote some resources to this issue, that they do it well, or ways that would be less fruitful?
Well, far be it from me to tell AGs how to do their job, but I think that the model that we have seen over the last couple of years that's developed between our office and the New York State Attorney General is instructive going forward. As I mentioned, working together on these kinds of cases raises a lot of complications, but they are complications that can be overcome with a lot of communication with our office. These cases tend to be extremely complicated, difficult, document intensive, and can consume a lot of resources and both personnel, technology, and time. And they are not easy cases. And they are obviously, I think anybody who's worked on these know that they are often extremely well defended. And so one of the things I think I would just point out is that when you decide, to sort of take on one of these kinds of cases, you really do need to devote the resources to it. And we obviously devote tremendous resources to these kinds of cases. Just the mutual fund cases alone, we have people in every one of our regional offices working on these cases. And just to pick up on the last point, I think, one of the dynamics that sort of goes on in the investment banking and capital raising industry is there is always the drive to innovate, to come up with the next way to finance something, the next way to raise capital that provides financing through a new method. And I think there is, for better or worse, resources devoted on that side of the fence to figuring out ways to get around existing regulation. And the profit motive obviously is a big incentive for that. And so I think one of the obligations on us is not just to look for the frauds that we know about because we've seen them already, but obviously to look for the kinds of frauds that are developing and that are being created as we speak, because it's the ones we don't know about that are likely to be the biggest harm to investors going forward.
Thank you, Ralph. I wouldn't be doing my job if I didn't try to at least help people understand where there are potential or real friction points within states, between the different regulators, or state and federal difficulties. Can you comment perhaps on examples you've seen of where there were good or bad things to avoid, things to do, that are grounded in real experience?
It's an interesting question. I tend to think that the cooperation level that we see is greater at the states. I think the states serve a model of cooperation amongst themselves because they have the same values of investor protection and looking at it from the standpoint of protecting the citizens within their border. And where I see somewhat of a divergence, and I just noted that in our colleague Mark's comments, there were not examples, but statements regarding complications of cooperation or complexities of cooperation. And I tend to think that you need to overcome those complexities because at the state level, we shouldn't have those. We have the same goal. So I don't know why we did the analyst cases jointly. We do hundreds of cases jointly. We did the sweeps together. We work with the SEC on some of the issues that they raise, but we need to make sure that can cooperation be improved? Yes, but it also needs to be improved. The communication needs to be improved also, and we always have room for improving communication because I think that you're representing a particular view of your constituents back home that I think there's a reliance on for you to bring to that table and express those views into these settlements or into the cooperative overall goal of investor protection.
If there's an AG question, raise your hand while I call on Tom Miller.
Well, we in the AG family, I think, have an excellent model of the kind of cooperation we're talking about here. And that's in the predatory lending area. In predatory lending, obviously, we have responsibility, other state agencies, financial regulators do, and the federal government does. So what did we do? Well, the FTC did the Associates Citibank case. We did the household case. And within the household case, many state attorney generals were involved, their offices, and many financial regulators were involved. We put together a wonderful partnership. We came up with one position, and only one position, that the company had to deal with, and had the largest settlement, the largest consumer settlement in the history of the Republic, state or federal, with household, $484 million. And you know, at least 30 active AG offices, at least 25 to 30 financial regulator offices, that we came together, worked everything out, and had one single position, and I think a terrific success.
General Madrid, question.
I think Patricia Madrid, Attorney General of New Mexico, a small state that does not have the staff of the New York AG or the California AG. But your question was, what can all of us attorneys general do? I think what you're talking about today is about prevention, prosecution of corporate fraud, and protection of individual investors. But the attorneys general have to remember that our main client is the states. And my little state, for example, lost $50 million on our investment funds on Enron alone, and many, many millions more on WorldCom. And so I think every attorney general has to be very, very aggressive in representing those funds that were lost for each of our states and going after these companies and not ignoring it. Every case that you can get involved in, I think you should do that. Because I'm not willing to just suffer these losses for my state. It was a huge hit. And that's, we have to remember, is our first client is the state and our investment funds.
Good point. And of course, our roles as sometimes advisors or lawyers to the institutional investors in pension funds and so on are very, very notable and extraordinary. Well, we're going to begin to wrap it up, but do you have one last thought, Jeff?
One last quick thought. I don't think it's over yet. I don't think the excesses of the market have been wrung out. I don't think the excesses of attitudes about free markets in Washington, New York, and around the country have been wrung out. I think there'll be more problems to come and more tendencies to continue to adopt these kinds of practices. It's not over.
Thank you. Will you all join me in thanking an extraordinary panel for their... Next, I want to ask a gentleman that's been associated with these efforts, along with Mr. Shorenstein, to try to put these programs together around the country, to make an introduction of our next speaker. Leon Panetta, of course, you all know from prior life as the Chief of Staff in the White House. Of course, those of us in California knew him as an extraordinary California congressperson from the Santa Cruz, Monterey parts of California and some other parts. He and his wife, Sylvia, currently direct the Panetta Institute, a nonpartisan institute for public policy in California. He's with us to introduce our congressional speaker. Leon, thanks for being a great friend and helping out.
Thank you very much, Bill, and thank you for your leadership here. And I want to thank all of the panelists for the contribution that they've made to this issue. And I want to commend all of you for the commitment and dedication that all of you have to make to law enforcement and the pursuit of justice. I also want to express my thanks to Walter Shorenstein. We've worked together to put on these panels, but no one is a better example of integrity in the marketplace than Walter Shorenstein, and we thank him for his generosity and for his commitment. It's appropriate that, having heard from state enforcement, having heard from federal enforcement, and having gotten kind of a public view of this issue, that we also hear the view from Capitol Hill in the Congress. Congress has obviously taken action in the corporate governance area, and the question is, what is the role of continuing oversight by the Congress, and what additional action is possible? At the center of that effort in the Congress is Congressman Mike Oxley. Mike is an outstanding member of the Congress. He is chairman of the new House Committee on Financial Services, and from my perspective, he is, more importantly, a friend and a former colleague in the Congress. In the Congress, I've always defined good members by the fact that they truly understand their constituents and that their roots are in the district that they represent, and their life is tied to the people who elected them to office. Mike is one of those individuals. He was born, raised, educated in Ohio, got his law degree from Ohio State University, served as a special agent at the FBI, so he's had law enforcement experience, and then was elected to Congress in a special election in 1981. He's serving in his 11th term in the Congress. He's also chairman, as all of you know, of the House Committee on Financial Services, which is at the heart of looking at the law with relationship to corporate governance. He was involved, obviously, in what became known as the Sarbanes-Oxley bill in the House, that is known as the Oxley-Sarbanes bill, and worked very hard to put that legislation together and get it through both the House and the Senate. But most important, let me just share from you, from an individual point of view, that Mike and I come from the same generation in politics. It's a generation that always believed that the purpose of public service was to solve problems. We live at a time when in the Congress there is increasing partisanship, and obviously politics plays a larger and larger role from day to day. But Mike Oxley is one who still believes that the fundamental responsibility of a member of Congress is to work on good policy for the country, and to do that in a bipartisan way, working with both Democrats and Republicans. When I was in the Congress, there was a group of us that oftentimes would have the chance to go down to the gym and play basketball, both Republicans and Democrats. And one thing you ought to know is that Mike Oxley has probably one of the best three-point shots in Capitol Hill, which may tell you a lot about how he operates as a member of Congress. The question that we have had before us is, how do we restore integrity and trust in corporate America, and maybe to a larger extent in government itself? Congressman Oxley will play a very important role in both of those efforts. Let me then introduce an outstanding member of Congress, the chairman of that committee, and more importantly, a good friend, Congressman Mike Oxley.
Leon, thank you very, very much, and it's great to be here before all the attorneys general all over the country. And Leon, I'm so glad you mentioned basketball, because I was going to take a few cheap shots at your basketball abilities, but you beat me to the punch. But it was always fun, and somebody asked me the other day, a constituent, and we were talking about some different issues, and he looked at me and he said, what's the best part, what's the most fun about being in Congress? And I thought for a minute, and I said, actually, it's the basketball games. And he didn't quite understand that, but I know you do. And we thank you for your service. When I came to Congress in 1981, in a special election, of course, Leon was already one of the senior leading members, and of course became budget chairman, and then went head of the budget office for the president, and ultimately the chief of staff. So he has truly defined public service for all of us, and I really appreciate the opportunity to come before you. When Leon called and said he'd like to have me come over and speak to the AGs, I'd say I'm really thrilled to do that. My own favorite Attorney General is, you thought it was you, didn't you? My own favorite Attorney General is none other than James Petro, Jim Petro has come a long way. When I first got involved in politics, I was working on Bill Saxby's Senate campaign. Bill was the Attorney General of Ohio and ran for the United States Senate in 1968, and I was still in law school, and I was an advance man for Bill's campaign. And that took me all over the state, and I was able to somehow schedule my classes, kind of front load them on Mondays and Tuesdays and Wednesday morning, and then I would take off and we'd go all over the state campaigning for Bill Saxby. And that's when I first met this kid who was driving the campaign van. I was actually working with his older brother, who taught me an awful lot about politics. And that's how I met Jim Petro, who was driving the van. I'm not even sure he was old enough to drive that van, and I think we may have ended up in a ditch or something, as I recall. But to my amazement, he's had a great public career in Ohio, in the legislature, the auditor of state, and now Attorney General. So we're really proud of you, Jim. And it's great to know that somebody that started out driving a campaign van is now the Attorney General of the Buckeye State. And we're glad to have you here. I was up with my namesake, Paul Sarbanes, up in New York, and we were honored to speak to the Economic Club of New York last month. And it was quite an opportunity to discuss the Sarbanes-Oxley Act, and we've got kind of a little shtick going now as we go around kind of a road show talking about corporate governance. And we both tell our stories. I say that, you know, my hardest thing I've got to do is convince my constituents my first name isn't Sarbanes. And Paul wants to know why everybody at home is asking, in Maryland is asking why he has a hyphenated last name. It's been quite extraordinary. I went to the World Economic Forum last year over in Davos and was asked to speak to a group, and we were having cocktails beforehand, and a fellow came up to me, I think he was from Singapore, and he saw my name tag, and he said, Sarbanes-Oxley, I'd like to shake hands with Sarbanes-Oxley. And I said, why is that? And he said, well, I never got a chance to shake hands with Glass-Steagall. But anyway, we've had a lot of fun with it. It has been, and I'm glad, by the way, Leon, that I got here early to hear the panel, because it does kind of give me a little bit of flavor of what issues are on your mind and so forth. And I thought I would at least talk a little bit about, now I wanted to talk about the obvious issue of cooperation between the feds and the states, and that's evident. But at the same time, to say that the reaction of our system to these corporate scandals is quite extraordinary. That we have somehow the political will to confront very real problems in our country and stand up and address them and try to solve them as truly as problem solvers, as Leon said. That's pretty unique in the world. I mean, if you look at some of our competitors and trading partners, they don't apparently have either the political will or the system that's flexible enough to deal with these very difficult problems and come up with solutions by working together. It's really quite extraordinary. If you compare our system, for example, to Japan, you know, Japan has had how many years now of no growth and major problems with their system. That was a system, of course, that was supposed to be taking over our system. They even bought Pebble Beach out in your territory. And there were a lot of folks out there that said that this is the new wave, that we need to move towards a Japanese Keiretsu system. How does that work out? But in fact, everybody knows they've got bad bank loans. They continue to prop up bad banks. They won't allow any of these banks to fail. And they continue to slog through. Or our friends in Germany, the largest economy in Europe, the driving engine of growth in the European Union, with double-digit unemployment, with a large state sector, with unfunded pensions beyond belief, with laws that say you can't fire anybody, and the natural consequence is you're probably not going to hire anybody if at some point you can't fire them. Very, very restrictive kind of a system that doesn't have nearly the flexibility that we have. And so when we're faced with these perhaps unprecedented corporate scandals, although I guess if you look back in our history, we've had seemingly every 20, 25 years a wave of these kinds of scandals. They're perhaps different every time, and this may have been hopefully the granddaddy of them all. But in fact, it's not unusual in our entrepreneurial capitalist free market system to have some of these things jump up and bite us. People taking advantage of the system, people looking for the edge, in some cases being driven by unrealistic expectations of quarterly profits, and on and on and on. And so for our system to confront the problem, and again, this was a constituent-driven problem. I had people in Findlay, Ohio, perhaps a great example of a very robust small town. We have 2 Fortune 500 companies in my hometown of 40,000 people. To confront people who had invested and then saw these investments dissolve under more and more scrutiny that came out with all of the activities that were taking place, illegal activities. These people were disturbed, to say the least. And we, I think all of us felt in public office that surge of revulsion that the American investor felt, and indeed the American citizens, even if they weren't invested. And we all felt that, and that's why we responded. But I think we responded in a very positive way. We have changed tremendously in this country. I came to Congress in 1981. When I came to Congress in 1981, 19% of American households owned stock. Today, it's 52%, 23 years later. Remarkable, and still growing. And the exciting thing about what we discovered during these terrible times where there were more revelations, one after another, that for the most part, the individual investor stayed put. They stayed in the market. They didn't panic. They didn't sell out. They had trust that our system would correct the problems inherent in what we saw come out in the news media seemingly day after day. So we started the process with hearings, and we had an opportunity to study the whole issue, ultimately passed far-reaching legislation, the first ever legislation of its kind, probably since the 33 and 34 acts that created the SEC and our existing capital market structure. And it was done on a bipartisan basis. Here's a conservative Republican from Northwest Ohio working hand in glove with a liberal Democrat senator from Maryland. What could be more bipartisan and indeed more American, and how it represented essentially the best of our system. And probably no matter how long I stay in the Congress, and probably no longer how as Paul stays in the Senate, ultimately our names will be joined, I guess, forever, for better or for worse. And yet, I suspect that when we all get a chance to look back and take a perspective on this, we'll find that it was in the best tradition of the American system of solving problems. And while we get a lot of attention for the act, the fact is that you folks, and NASA and SROs and virtually everybody who has a stake in this system was also responding very favorably. Somebody said, this is not over. Probably not. The world doesn't work that way. There are still people out there that will take advantage of a system. They will try to get the edge. We have laws against murder. but people murder each other every day. And so we need to understand that to change attitudes and change the system is a very difficult thing to do, and we've tried our best to do that. We have some responsibilities that we share in terms of our separate constituencies. Jim Petro and I have, in some cases, the same constituencies. Others we don't. And we need to be able to try to coordinate that as best we can and cooperate as best we can, given the system that we have, which is a pretty doggone good system, the federal system. And I applaud Eliot's efforts, all of your efforts at the state level. This is something that is bigger than all of us, that we need to work together on and to solve the problem. And I, in all honesty, think we are well on our way to doing that. We created the Public Company Accounting Oversight Board. Make no mistake about it, this was a huge change in the way we've done things. We essentially federalized a profession that for forever had been self-regulated. And then we found out that self-regulation just simply wasn't working in today's modern marketplace. And so we created this oversight board. And we're fortunate to have really qualified people led by Bill McDonough who gets it, who understands the role of the board, who understands that he needs to go out and reach out to the accounting community and the auditing community and as he said publicly, to work on a redemption as opposed to a punishment. And I think he's making great progress. Bill Gradison, our former colleague, Leon, is also a member of that board. Bill and I were out at Ohio State University last month speaking to the business school and to a lot of the students. And the one thing that I think Bill and I both felt coming out of those meetings with the students and the faculty was that they felt that we were on the job, that there's somebody out there looking out for their best interests, making certain that people act in a legal and responsible way, and they're going to continue that effort. So I give a lot of credit to Bill McDonough and his leadership. He didn't have to take that job. Maybe it's just serendipity that the SEC Chairman Donaldson is his neighbor, and that Bill Donaldson, as he says, went over on a Sunday afternoon and sat down and talked, and as a result, we got Bill McDonough. And we also were fortunate to get Bill Donaldson as well, who's worked very closely with Eliot Spitzer and some of the other AGs to craft settlements, to make certain that as best we can, we take care of the victims of this, and that's what we have to remember in the SEC. By creating the Fair Fund in our Sarbanes-Oxley legislation to be a conduit for fines and disgorgement money to go into that fund, and we're well over $1 billion and counting. I think we just got some more here recently. But the idea is to use that in the best way possible, identify people who were victims of this illegal activity and try to make them as best we can, try to make them whole. That is what our job in government really is. And we're making huge progress as a result. And so I stand here today, and I'm sure Paul would say the same thing, as willing partners with the states to make certain that our efforts at regulation and enforcement are seamless, that are in a smooth, cooperative effort. Will there be some differences of opinion? Of course. Occasionally, Eliot and I, believe it or not, have a difference of opinion. But that's New York and Ohio. You know, that's just the way it is. But in fact, most of us, all of us, really do share the same goals towards that end. Now, today, we received a letter back on the 529 programs, the college education programs. I had received some information about some questions that were raised about those state funds. I wrote a letter to the chairman of the SEC. He responded today So I really, other than his cover letter, haven't had a chance to look through, but they did a very thorough job at the SEC of answering our questions, and you folks will have a role in this. Over the times that we've had hearings, we've had testimony from people at NASA, people from the attorneys general, all of the different state functions. This will be an important issue as to how these plans, which are growing, and that's a good thing, how these plans are regulated, how much information is available to the investing public for perhaps one of the most important decisions that any parent has to make, and that is creating enough capital, enough money to get their kids through an ever-increasing cost for higher education. There is an opportunity, I think, where we in the Congress, along with the SEC and the states, can work in a cooperative way to make certain that those people who have entrusted the state with their money for a period of time have the confidence of knowing that it's being well taken care of and that their ultimate goal of having enough money to put their kids through college at the end of the day has been met. That's how I see our system continuing to evolve. We've got a lot of good people in government today. We are, I think, very, very fortunate. Sometimes we are ridiculed in the popular media, those of us who represent constituencies. But by and large, the day in and day out activities of your offices guarantee my constituents the kind of satisfaction knowing that you're out there after the bad guys, whether they're turning back odometers or whether they're ripping off the investors. My people feel more confident every day that that's being accomplished. And it doesn't hurt, by the way, to have a few top executives prosecuted and sent to jail. That is a huge deterrent, a huge deterrent. When I went home after we had passed the act and started talking about the provisions in the act and how they worked, virtually every time I spoke to a local service club, the first question was, when are some of these guys going to go to jail? They didn't want to hear all the niceties about more transparency and all of the other issues that I tried. They wanted to know when these crooks were going to go to jail. Well, we're starting to see that. And sometimes justice runs slowly. That's called due process. You know, we don't just take them out and string them up anymore, at least not in Ohio. I don't know about some states, but we're a little careful about how we do that. But at the end of the day, I think it sends a strong message to our constituents that everybody is on the case. And so, yes, there will be some more of these without question. I don't think there's any doubt about it. It'll probably be different. The names obviously will be different. The methods will be different. Anybody that thought that after we dealt with Dennis Levine and Michael Milken, that somehow that was going to be the end of it, obviously doesn't know the genius sometimes of the American mind. But our role is to continue the process. And frankly, and I'll close on this, the key, I think, element, whether it's going to be dealing with mutual funds scandals or with corporate scandals, is transparency. Transparency. Allow this increasingly sophisticated investor, these 95 million people that own mutual funds, or the more people that even, the 52% of households that own equities, give them the information they need to make a wise decision in the marketplace. And if you look at the numbers in the mutual funds, the people that are getting out of mutual funds are getting out of the mutual funds that have been accused of wrongdoing, because the actual flow is at record levels into mutual funds, because people essentially trust our system, but they say, I want to make certain I get into a fund that's going to treat me fairly and honestly. And the other ones are not. And these people are going to vote with their feet. And that's ultimately the best solution and the best deterrence against illegal behavior. I thank you so much for inviting me. It's great to be here. Thank you all.
The Congressman agreed to respond to a couple of quick questions. I only would provide advice, Congressman, as someone from the San Francisco region, that I'd be careful how you talk about the partnership with Sarbanes and Oxley. The question I'd have, we've all, I think, heard business people express worries about what they view are constraints that on their governance from the Act. How much of that have you heard, and how much do you worry about?
That's a good question. I think that there are some issues, particularly as it relates to Section 404, which is admittedly almost like a belt and suspenders kind of approach to the issue. And I think it's something that we thought about. We tried to give the SEC and, in this case, the Public Company Accounting Oversight Board enough flexibility to be able to deal differently and not a one-size-fits-all with the smaller and medium-sized companies as opposed to the large companies. There was a lot of predictions, if you'll recall, that a lot of corporations would go private to avoid the strictures of the law. That has happened, but in a relatively small number. As a matter of fact, a couple in Ohio actually did that, but at the end of the day, that's their choice. It may very well be that they would be better off as a company to go private. We had complaints from the European side, at least until Parmalat, that this was extraterritoriality. It was we were trying to control what the Europeans did. But our message was to the European companies: look, if you want to come into the richest and deepest capital markets in the world, then you basically have to play by our rules, and we don't think it's asking that much. Now, I took a lot of grief over in Switzerland because it was right after the act had passed, but I think I feel somewhat vindicated by some of the scandals that are coming out in Europe that they're not immune either from that kind of activity. But this is also an ongoing process. This is not the end of the process. In many ways, it's only the beginning. And we'll plan to continue to have oversight hearings. We want to listen to people. The last thing we want to do is try to restrict the free flow of capital in this country. That's really what has made us great and made us grow and created growth and created capital in this country. But at the same time, I think it's important that we do send that message to those people who invest in America, who invest in these companies, that they're being treated on the up and up.
Mike, do you expect Congress is going to pass any additional legislation between now and adjournment in this area?
As you know, Leon, we passed a mutual fund bill in the House. Richard Shelby, my counterpart in the Senate, has had some hearings, but in the meantime, the SEC has been quite aggressive in moving in that direction. It's a possibility that we could get together in a conference committee if the Senate does pass a bill. But I have great confidence in Chairman Donaldson and the SEC that they will do the right thing in the area of mutual funds. In a perfect world, it would be best left, in my estimation, to the rulemaking body, the SEC, an independent agency. So I think probably not likely that we're going to see, other than perhaps a mutual fund bill, that we'll see much in the way of legislation in that field.
Anyone else on this topic? Thank you, Congressman.
Thank you all very much. Good to be here.
Again, Mr. Shorenstein and staff, Cindy and others, thank you very much for your assistance. We've concluded until 2:30 to board the bus for DOJ. Thank you all very much.